Okay, thank you. Trish, thank you very much, and it's a great pleasure to be here. Thanks to the ADA for inviting me again. I said to Trish, I haven't got anything to say this year, but she said, never mind, come and talk about something else. So here's the alternative title to my presentation, and as this morning is about access to content, I'm just going to give you a snapshot of some factors and influences with a little bit of international insight from overseas, and talking about developments in access to content. As Trish told me, most of the audience are non-lawyers, so this is a pretty non-legal presentation. Let me just start by mentioning the competition review, the Harper review as it's called. This review started last year. It received 350 submissions. Some of them are confidential, others are available online. A draft report has been published, and it recommends freeing up the market for copyright goods by significantly eroding blocks on parallel importing, including geoblocks. And submissions on the draft report were due in November 2014. They are also available online, and the full report is due next month in March. A strong note of caution has been sounded by copyright industries and groups on opening up the market. A year before the competition review, the IT pricing inquiry in the House of Representatives took place, and it also became very concerned with geo-blocking issues as well as illegal downloading. Two different issues, but related in some people's minds. The report of the House of Representatives in the IT pricing inquiry looked at economic research. This is much disputed, this economic research, but it noted that in their opinion, there was no need to allow prohibitions on parallel importing of any sort, and that in fact geo-blocking should be completely banned, not just not allowed, but banned. They also talked about online infringement, and they felt that the impact on copyright owners was far less severe than rights holders claim, and that household spending on entertainment and growth in employment in the entertainment industry and the number of creative works being introduced has grown at a tremendous rate, and that's a quote from their report. The pricing inquiry did not consider that technological change was harming the market for entertainment and IT products, and it certainly didn't accept the market was being decimated as some had claimed. Now, the competition review doesn't go as far as the IT pricing review. I've put up on this slide now just a few examples taken from the Harper report of examples of how parallel importing can be facilitated by consumers, particularly overcoming geoblocks. I'm not going to read that out to you. This is taken from the report. But you can see here that in terms of physical goods, mail forwarding companies can allow Australian consumers to buy goods overseas and then forward them to Australia. And indeed, Australia Post has set up just such a business. In markets for digital content, virtual private networks can help consumers access digital content in overseas jurisdictions at the prices offered in those jurisdictions. And obviously, consumers get online and compare prices and can make decisions about what they want to do. Okay, blocking geo-blocks. International trends in similar jurisdictions to ours, particularly Canada and New Zealand, smallish, wealthy markets, much like Australia, they're tending to facilitate consumer access by allowing circumvention of restrictions on geo-blocking and other forms of prohibitions on parallel importing as well. So not just electronic, but physical as well. And one of the most common examples that Australians have demonstrated in terms of overcoming geo-blocking is to subscribe to Netflix, the streaming service, the TV and movie subscription streaming service. And in recent months, there's been many reports of Australians covertly signing up for this service, using fake postcodes and software workarounds to fool the geo-blocking system. And one industry commission study has estimated that up to 200,000 Australians have subscribed to the service in this way, using VPN services to access the product. Now, this is probably conservative. There are other ways to get around the blocking of Netflix. One is, for example, if you get an address in the US, a physical address. So if you divine, for example, that a small Alabama chicken shop in a little town doesn't have its own Netflix subscription, you can give this address and you can buy gift certificates. Your credit card won't be allowed to be used by Netflix, but you can use that address and buy content using gift certificates, just to mention an example I've heard of. I want to say I wouldn't know how to geo-block, and I don't do it. I only ever buy legal content. I'm not saying that to be amusing. It's true. Now, I'm just telling you about other people, which is true. Geo-blocking circumvention, it's a common practice by all accounts in Australian households, and as we've seen, an industry is emerging to help people overcome geo-blocking. Many companies, hundreds, some people say, offer unblocking and identity masking services. I've just put up a few examples there. And there are various software solutions, detailed how to use guides on tech websites and even in the mainstream media. Now, there are fears that when Netflix comes to Australia, which is happening very soon, along with many other streaming services, in fact, the content offered will be inferior to the US, both in terms of price and quantity. However, very recently, on the 20th of January, Netflix announced that they have quite aggressive plans to sign content on a global basis, and the first markets in which they're going to try this are going to be Australia and New Zealand. So in other words, negotiate the rights for the whole world at the same time rather than geographic segments of it. At the moment, though, Netflix content, it's paid content, but a common industry view is that those who circumvent the geo-blocking are pirates. And the financial harm is suffered to the distributors of content who've paid for the rights to distribute and who argue that tidy distribution arrangements benefit the consumer. However, maintaining regional distribution licenses is becoming more and more anomalous. Okay, now, whatever you think about geo-blocking, some things are just downright illegal copying. And on the topic of unpaid copying, a discussion paper came out last year. And as we know, and I quote, "The rapid growth of the internet has brought significant challenges to the protection of copyright due to the ease with which material can be digitally copied and shared at little or no cost." And this is a quote from that discussion paper. By the way, that thing in small print at the bottom, I only noticed this morning. It is something I was going to talk about, and I must have parked it there thinking I'll get to it later. But due to time restrictions, I've decided against that. So, Trish, I'm sorry, I should have checked the slides before I sent them to you. The discussion paper was controversial. Its contents were leaked ahead of release. It's not entirely clear whether that leak was so the government could sort of pierce the bubble of criticism ahead of time, or whether it was a genuine leak. There was criticism about the process, that submissions were not published. However, many were put up by organisations anyway. And of course, there was criticisms of the discussions, of the suggestions in the discussion paper. And so a modified, in late 2014, a modified account came out, a modified version, where the government has announced two main things, really. One is that they're going to bang some heads together between stakeholders to try and get a code of conduct dealing with how internet service providers will deal with repeat infringing downloaders. And this is to be registered with the Australian Communications and Media Authority. And the other part of the plank is that this is going to be in accordance with the government's express preference for a market-based solution to the issue. And a mechanism will be developed to facilitate the granting of injunctions requiring ISPs to block access to overseas websites that host infringing material. And the Copyright Act will be amended to do that. There is a deadline of April the 8th for the parties to agree. The government says that it's sought the least burdensome and the most flexible way of responding to concerns about online copyright infringement while protecting the legitimate interests of the rights holders in protection of their intellectual property. There's no single measure, we're told, in the report that came out that can eliminate online copyright infringement, and the government's going to review, when I say the government, I mean mainly the two ministers, the Attorney General and the Minister for Communications, and this code and the amendments will be reviewed 18 months after implementation to assess their effectiveness. Now, the government also noted that the issue of affordability and accessibility of legitimate content is a key factor in reducing online copyright infringement. The government welcomes recent action by content owners and expects industry to continue to respond to this demand from consumers in the digital market. And certainly many digital subscription services have become available, particularly for music and streaming, and are becoming available, as we know, as I mentioned. And many of the submissions did point out the many ways of acquiring legitimate material. I think what our government's proposing might be called in the UK an holistic approach. This holistic approach that the UK IP Office applies has much in common with the proposed Australian approach. The Hargraves Review of Intellectual Property in England in the UK recommended combating online infringement with a cocktail of measures, really. Enforcement, education, and crucially measures to strengthen and grow legitimate markets in copyright and other protected fields. And you'll see from the slide up here this multi-pronged approach. There's a legislative framework that allows for offences including conspiring to defraud, for example, downloading material known to be illegal. There are voluntary interventions, agreements between rights holders and the relevant industry with the aim of making online infringement more difficult. And the UK government hosts regular stakeholder roundtables to get rights holders and internet advertising agencies and other stakeholders together in this self-regulation process. I think this voluntary intervention is fairly mandatory, like in Australia, the code that's being developed. I think it does require a bit of enforced getting together, but nevertheless, it's, again, this market-based agreement type of approach. There are administrative interventions, such as notifying ISPs when infringing material is up and obliging removal in order to maintain safe harbour status. So in order to get the protection of being a safe harbour, certain things might have to be done. And this is also something that's being worked on in the Australian context. Obviously, work is done identifying infringing sites and the possibility of blocking payment facilities and notifying consumers through mass notification systems is another thing that happens in the UK. The UK is part of a harmonised EU system, and there are processes for working out rules that apply for the grant of injunctions against intermediaries when services are used by a third party to infringe copyright and indeed other rights. So the UK places great store on understanding consumer behaviour and working with that, and Hargraves found that enforcement and education alone struggle to make an impact on consumer behaviour. Evidence suggests that lower-priced legal products have the most effect on illegal downloading. Now, I've mentioned evidence a couple of times. I'm going to come back to that in a minute. But both in the UK and Australia, making consumers aware of how to access legal material has been undertaken. And in Australia, a digital content guide has been developed, particularly over the last 12 months or so. And in the UK, the content map has been created. And both of these are online portals which showcase legal services available to consumers across film and TV and e-books and music and games and sport. So again, a very useful part of educating consumers. All right, a significant aspect of Australia's intellectual property regime is the growing number of free trade agreements. And so we ask the question, what effect do these have? Well, the most significant one came into force 10 years ago, 1st of January 2005, the Australia-US Free Trade Agreement. And I've just put up there on the slide a number of quite significant changes to copyright law which took place, and I'm sure that most of you are very well aware of those. Now, we have a lot of, 3 or 4 or several recent free trade agreements, very recently concluded: the China-Australia Free Trade Agreement, the Korea-Australia Free Trade Agreement, very recently, just a few days ago almost, the Japan-Australia Economic Partnership Agreement, which is actually, when you look at it, I think more of a tariff-lowering agreement, not quite as extensive as the other agreements. Now, most of these will not need a lot of major change to copyright law, as the Australia-US Free Trade Agreement did, but particularly the CAFTA, the Korea-Australia Fair Trade Agreement, seems to indicate that we might need to look at action on enforcement to match what Korea is doing. They're a bit ahead of us in terms of online enforcement, but as I said, that is controversial. Now, in the meantime, the Trans-Pacific Partnership, the TPP, in brackets down the bottom of the slide, we hear around the place that the intellectual property chapter has been concluded. It's not public, as we know, and the whole agreement is expected to conclude this year. In addition, there's a Regional Comprehensive Economic Partnership. I don't know how you pronounce the acronym for that, RCEP, but this includes ASEAN countries and China, Japan, India, Korea and New Zealand. There's been almost no public discussion about RCEP and copyright issues to date. All right, now still thinking about free trade agreements, back to the Harper Review, the competition review. The draft report recommends, in bold, have an intellectual property review. Sorry, I'm not laughing. You will see here that the Harper Review thinks that there should be a lot of attention paid to what sort of principles should inform Australia agreeing to changes to intellectual property law when we're talking about entering into free trade agreements. So they want an independent, transparent analysis of the costs and benefits of proposed IP provisions. So they are sounding a warning note there. Now, as far as having an intellectual property review, many of the submissions to the Harper Review expressed considerable concern around having yet another intellectual property review. But there is also concern expressed by the Competition Review as to the sorts of changes that technology and markets internationally are creating and the sorts of things we should be agreeing to without a full analysis. And on that point, I just want to mention now the cloud. I've already mentioned that there were concerns in the Harper Review about developments in technology and developing international markets and international agreements. And cloud computing is an important and ever-developing aspect of government policy. The use of the cloud for the business of government, as well as business and consumer use, was part of the government's election platform. A national cloud computing strategy was announced at that time. This is now firmed up, if we can say that about a cloud, into a more explicit cloud-first policy. And government agencies are required to consider public cloud services first for all new IT procurements. And there is a very focused e-government policy to put the government in a leadership position on digital economy issues. Now, coming out of that, the idea is that all government services should be available digitally by 2017, which is not that far away, and government businesses to move to the cloud and government agencies are to use cloud services. And I've just put a little bit of information there about how that will be provided. But we've already heard this morning 3 speakers talk about issues of digitising material and the uncertainties around using that material. Issues of cloud and digital services, we're talking about a completely digital environment. We're not talking about you can come into the office and inspect this map or this plan. We're talking about it's all going to be available online. And as I know, as you will know from the submissions made to the Australian Law Reform Commission's Digital Economy Inquiry and also submissions made to the Harper Review, going totally digital raises many issues of access and uncertainties. So we're not just talking about forms, we're talking about maps and surveys and other sorts of information. And this challenges quite a lot of existing copyright rules and practices, and stresses the need, I think, to look at exceptions in the Act. And certainly Alison referred to this morning to some difficulties in making material available, as did Robin and Elise just now. And these, I think, will be compounded if the government is saying that all government services have to be provided online from the cloud. Okay, now, Australia's not alone here. Sorry, I keep going the wrong way. Australia's not alone here. In the UK, cloud computing and a whole digital infrastructure are seen as key planks of government policy as well. And in fact, Australia is seen as a good market for IT and cloud services, and the UK government is running tech missions to Australia to harmonise cloud policy and regulation, and also hope that we'll be a market for that sort of capability. So we're not the only ones here, and this emphasises, I think, the need for some sort of global agreement on how to use the cloud. Fair use, of course, would be a good development for cloud computing. Okay, that's my full report. A year ago today, the ALRC Digital Economy report was made public, and we haven't heard anything else about that since. The UK has introduced, though, in the meantime, some more fair dealing exceptions following the Hargraves review. These exceptions have been produced in 2 tranches, and we saw that the first lot listed there introduced just last year, after some analysis and evidence was presented. I'll mention that briefly now. This is, just before I go on to that, I just want to mention the US Board on Science, Technology and Economic Policy. In 2013, it noted that numerous industries claim they need flexible limitations and exceptions to copyright law in order to exist and flourish. And this board is now going on to, among other parts of the US system, Congress, to review copyright law in the US to see what changes need to be made. Now, the changes that have been made in the UK, when asking what sort of changes should be made to copyright law, what would assist innovation, the Create Centre came out of the Hargraves Review. It's one of the main recommendations and outcomes from the Hargraves Review. And this is the Centre for Copyright and New Business Models in the Creative Economy. This is a consortium of 7 universities based at the University of Glasgow. And the aim of this centre is to grapple with the question of what amendments should be made to copyright law, and importantly, what evidence is there that these are needed. And before the recent amendments were introduced, the fair dealing amendments, the researchers at the centre produced a number of reports for the UK IP Office on what likely effect these amendments would have based on the evidence available. So, for example, on the subject of parody, there's now an exception for fair dealing for parody in UK copyright law. They did an assessment of what effect parody would have on the owners of the material. They had a look at more than 8,000 user-generated video parodies on YouTube relating to the top 100 charting singles in the UK for 2011. And they found that the presence of parody correlates with and predicts larger audience for the original material. Only 1.5% of parodies can be construed as taking a negative stance against the original. Of course, moral rights is always a concern. The parodies somehow infringe upon those. On the whole, not. And overall, parody grows the market for the legitimate material. So that exception is going to be good for everyone, is the report they made to the IP office. And it's not just parody. They also look at lots of other issues. Their work has shown that libraries and archives are a significant source of learning and innovation and have contributed evidence to support relevant exceptions in those areas to UK copyright law. And so we see there exceptions have already been adopted for research and education and libraries and archives. And CREATE has very recently contributed to the European Union review of copyright rules by summarising the available evidence in several areas of that inquiry, and they are also critiquing the methodology of that inquiry, which they feel they can do from their evidence-based perspective. Well, I'm just going to finish with one more, if I go the right way, one more interesting aspect, I think, of access to content. The Wigmore Association, or the Wigmore Collaboration, is a group of traditional old economy corporations which invest in new world technology. These are not my terms. This is how they describe themselves, old economy corporations investing in new world technology. Then mainly family-based companies with traditional businesses, for example, retail. Probably the Meyer family is the one most familiar to us in this country. And next month, in March, this association is going to Silicon Valley to explore opportunities for their old world money to invest in emerging technologies. And there are two aspects to this. The primary one really is broadening their investment base away from their traditional activities. But the other aspect, of course, is that even old world activities require technology in order to maximise their way of doing business these days. And as with governments and increased interest in cloud computing, companies get involved in new technologies and ways of doing business. And the idea is that these ventures will increasingly fill the void left by manufacturing and mining as traditional drivers of economic growth and job creation. And I've put a quote up there. This is from a man called Paul Napthali, who is the principal of a venture capital firm to invest in Australian startups. And he says there, future wealth will not be generated by digging things out of the ground. And you can read the rest of the quote there. Now, if there is a review of intellectual property, we can expect representations that copyright law needs to be amended to allow for innovation. And these points are already made in current reviews. If you look at the submissions to the Harper Review, you will see these points being made. So I think, among other speakers this morning, we asked the question, will copyright law be flexible enough in the future to allow for this? Thank you.